So just a little bit about LTCCC. We are a nonprofit, nonpartisan organization dedicated to improving care and quality of life for the elderly and disabled in long-term care. We do this through policy research and analysis, systems advocacy, public education, and we are also lucky to be the home to two local ombudsman programs in the Hudson Valley. So today we are really excited for this webinar. We have the attorneys who are suing the Maryland Department of Health for failing to provide meaningful enforcement of resident rights. And again, this recording will be available by the end of the week. But without further ado, I will pass it off to our presenters.
Thank you, Haley. Hi, my name is Regan Bailey. I'm the litigation director at Justice and Aging. I was going to start off our conversation today, but I just want to introduce some of the other speakers. Leah McGivern works with me at Justice and Aging as well and worked on this case. And Toby Edelman is from the Center for Medicare Advocacy, and she filed an amicus brief in this case. So thank you so much for joining our webinar today. This is just to talk through a case that we brought in the state of Maryland. It's a federal litigation. We brought this case because we've been concerned about quality in nursing facilities, as many of us are. It's a longstanding problem. And we've wrestled as advocates with how to ensure better oversight from the state and trying to find a legal theory that would work there. We studied the Maryland nursing facility system for over 2 years. We were looking at survey data and complaint data, racial and demographic data in nursing facilities, compliance issues, all information that's publicly available either from CMS or Maryland websites. And then we met with many nursing facility residents and learned more about the challenges they face getting the care they need. And a trend emerged. During that process, residents with mobility issues experienced unique challenges when their care was not provided. For example, most relied on more staff to assist them, using the restroom or going to the common area to socialize than residents without mobility issues. And many residents had made complaints to the state where they were not assisted in those ways and sometimes quite significantly under-assisted in many ways. And those complaints were not acted upon sometimes for years. So we turned to the state and federal protections to see what a state was supposed to be doing in terms of overseeing nursing facility quality. And I'll just turn to Toby Edelman to walk through the federal protections there.
I'm sorry, Regan, could you just tell me again? I was looking at something. Tell me what you want me to say about the federal.
Sorry, the Nursing Home Reform Act.
Okay, thank you. Okay. My job in writing an amicus brief in support of the plaintiffs was to provide background information about the Nursing Home Reform Act and the importance of the survey process to protecting residents. The point was not to make the legal and factual arguments that plaintiffs were obviously going to make, and very ably, as you'll hear. So this is a brief summary of what I wrote in the amicus brief. In May 1982, the Reagan administration issued proposed regulations deregulating nursing homes. There was supposed to be deemed status for the Joint Commission on what was then called the Joint Commission on the Accreditation of Hospitals. Self-surveys, nursing homes could report to CMS, or it was then HCFA, whether they were actually in compliance with standards, and less than annual surveys for so-called good facilities, among other proposals. There was strong bipartisan congressional opposition to these deregulation proposals, legislative moratoria preventing deregulation, and then an agreement. The administration would have a contract with the Institute of Medicine to do a study, and no changes were permitted until the IOM issued its report, which didn't happen until March 1986. The report began by acknowledging the broad consensus that nursing home regulation allowed, quote, too many marginal or substandard nursing homes to continue in operation, close quote. The Institute of Medicine proposed reframing nursing home law to focus on residents' actual needs for high quality of care and quality of life, and whether facilities were actually providing those high quality services. The report was a major part of the legislative history of the Nursing Home Reform Act, which was enacted in 1987, December. The reform law broadly defined the role of the federal government to assure that the requirements of care and their enforcement are adequate to protect residents' health, safety, welfare, and rights. The survey process, which was the least controversial part of the law, required that surveyors be trained and pass competency tests before conducting surveys. Standard or annual and complaint surveys are all unannounced. Under the rules that the administration issued to implement the law, when facilities are cited with deficiencies, they must submit a detailed plan of correction. This plan of correction requires facilities to make specific changes for each resident who is affected by the deficient practice and to take action to ensure that the poor care practices did not recur for that resident or for any other residents now or in the future. Information from surveys also had to be made publicly available. The importance of this survey process was highlighted for me by the Senate Aging Committee hearing in May 2023 called Residents at Risk, the strained nursing home inspection system and the need to improve oversight. The HHS Office of Inspector General described the state survey agencies as, quote, the front lines for protecting nursing home residents from substandard care and unsafe conditions, close quote. Erin Bliss of the IG's office said in her written testimony, quote, the importance of state agencies' roles in identifying and correcting poor care by nursing homes cannot be overstated in light of the long-standing and persistent problems that affect resident health and safety, close quote. She testified about the critical need for timely surveys, better verification of the correction of deficiencies, and improved accuracy of deficiency data reported on the federal website Care Compare. I next described our experience when California publicly announced on October 1st, 1990, that it would not implement the Nursing Home Reform Act. That was the date that the law went into effect. We filed a statewide class against the state and federal governments. What's significant for our purposes in the Maryland case is that the federal government withheld federal survey funds of $4.5 million for the 6-month period when California refused to use the federal survey protocol. Actually, the federal government sent all the federal surveyors in the country to California to conduct surveys. That federal action made crystal clear that using the federal survey process is not optional for states, it's mandatory. Finally, I wrote in my amicus brief about the importance of having accurate survey information, which is reported on the CMS website, Nursing Home Care Compare. That website reports information on three domains, health inspections, staffing information, and quality measures, which are largely self-reported information from the resident assessment information. Care Compare also reports an overall rating, which begins with the survey process and goes up or down by a star, depending on the highest or lowest scores in staffing and quality measures. Most facilities' overall rating is the same as the health inspection rating. My point was that if the survey information is years out of date, as it was in Maryland and continues in some other states as well, it's extremely misleading to people who are looking for a nursing home to place a relative, and also for people who have relatives already living in a facility and want to know what's going on in the facility. So that was the gist of the amicus brief, and I will turn this back to Regan. Thank you.
Thank you, Toby. And I think Liam's going to walk us through some of the state law in Maryland.
Yeah, hi everybody. My name is Liam McGivern. I'm an attorney on Justice and Aging's litigation team. Just first of all, thank you so much for LTCCC for having us, and thank you to all of you for joining us today. So Toby described the federal regime governing nursing facility oversight. I want to talk a little bit about state law. The federal law is a floor, but states can have their own requirements that afford residents even greater protections than what's afforded under federal law. There's two different ways that states can have those heightened requirements to protect resident rights. The first is having more stringent requirements for quality of resident care. And then the second is what our case is about, is more stringent requirements for the state agency in terms of their reporting. So, as I'm sure you gleaned from Toby's telling of the adoption of the federal requirements, it's a very long process and a very complicated process. States can, though, sometimes move more quickly to strengthen and protect resident rights. So, for example, states can have a minimum care requirement. In Maryland, there's a regulation that requires at least 3 hours of bedside care per day, 7 days per week. Now, there's no corresponding federal requirement, and there's been a lot of disappointment lately around the non-implementation of a federal nursing home care minimum care rule. So, in the absence of those sorts of federal protections, it is important to look to state law to see what may be there. Perhaps there's something there more for people. State law requirements can also be more strict as to the survey agency. So, for example, a state could require its survey agency to inspect and survey nursing facilities on a more tight timeline than the federal requirement that's 15 to 19 months. A state is allowed to be more restrictive than that. States can also be more restrictive in terms of their requirements for timeliness in investigating complaints from nursing facility residents or their families or other people from the community. For example, in Maryland, the requirements are tighter. Complaints have to be investigated generally more quickly than they do under federal law. So it's important to know your state survey agency's obligations under state law. And finally, there can be additional protections for nursing facility residents in terms of oversight of the survey agency itself. So, for example, in Maryland, there's recent legislation that increases the reporting requirements from the survey agency to the legislature and increases the legislature's role in oversight of the survey agency. So it's very important to not only consider federal resident rights and resident protections, but also to look to state law because they may be more protective of residents. And with that, I will hand it back to Regan. Thank you.
Thank you, Liam. So I was going to next discuss the Maryland case itself, and how the approach we took there, which was a little different than some of the other cases out there. In Maryland, we applied the Nursing Home Reform Act and the Maryland law to the requirements of the Americans with Disabilities Act, essentially saying that the state used a discriminatory method of administrating its system when implementing the oversight requirements. The way they implemented their oversight discriminated against people with certain types of disabilities. We partnered with the Public Justice Center, which is in Maryland, and a law firm to bring the case. And Toby Elliman, you just heard from her, filed an important amicus brief for us detailing the history and intent behind the Nursing Home Reform Act. Our legal theory was based on what's called a methods of administration claim, that the state's way of conducting its oversight of nursing facilities discriminates against nursing facility residents with mobility limitations because they were denied equal access to a benefit of a state service. The state service being the survey and complaint investigations, and the benefit being the enforcement of quality standards that are designed to protect resident rights and ensure quality care. We brought the case with 5 named plaintiffs, using pseudonyms to protect their privacy, and sought a certification of a class. The class definition that we asked for, and the court ultimately gave us, was a class of residents of nursing facilities who have disabilities with mobility impairment and who live in nursing facilities that operate under the oversight authority of the Maryland Department of Health. When we filed the complaint, we included key facts from our investigation. Notably, the plaintiffs had surrendered their life in the community in favor of placement in an institutional care setting to ensure that they receive round-the-clock medical care and assistance with toileting, hygiene, mobility, and other activities of daily living that they need to maintain their health, their safety, and their dignity. And dignity was an important part of our thinking in this case and a major theme in our advocacy. When we filed, more than 100 nursing facilities had gone more than 4 years without an annual inspection, and there was a backlog of thousands of uninvestigated complaints. Even though, as you just heard, federal and state law requires investigations within prescribed timeframes. At that time, Maryland was among the worst performing states in the country. Another area that we identified in our investigation was we found indicators of racial disparities, and we included those in our complaint. Many of Maryland's nursing facilities have a record of repeated poor performance over numerous review cycles. This was particularly true of nursing facilities located in Black communities. Across the state, in nursing facilities where the majority of their residents are Black, they tend to be low-performing 1 to 2-star facilities. These facilities need more attention from the state to bring up their standard and quality. We did not include a race-based claim in our case because the Supreme Court has held that only the Department of Justice can bring disparate impact claims based on race. But we did include the facts because they are an important part of the problem. So you may ask, why did we focus on residents with mobility issues? Well, it violates the Americans with Disabilities Act, or the ADA, when some people do not get the same benefit of a state service as others. While low quality impacts everyone, residents with mobility issues are harmed in unique ways. Notably, there's a class of members. There are class members in all nursing facilities in Maryland. In every nursing facility, there are residents who have mobility impairments. So the relief we're seeking in this case will go to anyone in a facility, across all facilities. When that facility is inspected annually, it helps everyone within the facility. And when timely complaints are investigated, then everyone is helped in the facility, regardless of whether or not they have a mobility impairment. We alleged that, quote, the failure to oversee and enforce rights and quality standards left nursing facilities unaccountable for their poor performance and poor quality of care, and leaves plaintiffs in situations where they remain vulnerable to neglect and mistreatment and loss of dignity. Without oversight pressures, many nursing facilities routinely fail to address these lapses. Ultimately, conditions do not improve year after year unless there is oversight. So I'm going to pass it off to Liam to talk about some of the impact that we included in our complaint on residents of nursing facilities.
All right, thank you, Regan. So let's start off with, what do we mean by mobility impairment? That's not a specific condition or a specific diagnosis. Our use of the term mobility impairment is very broad, and it includes many different conditions. The focus is not on the name of the condition or the diagnosis, it's on the impact on the resident. We look for things like, does the resident need assistance getting in and out of bed, sometimes with use of a specialized mechanical lift? Does the resident need assistance repositioning in bed? Do they have a need for the use of an assistive device or staff assistance for ambulation? Those are the things that we looked at in the case to determine which residents of nursing facilities in Maryland are mobility impaired, have a mobility impairment. So every nursing facility resident has a plan of care. So each mobility impaired resident's plan of care is going to detail what level of assistance they need. For example, 2 staff members and mechanical lift to assist in transferring in and out of bed. All that is going to be documented and memorialized in the plan of care. So that's what we mean by mobility impairment. It can be a wide range of conditions, from spinal injury to severe dementia and all kinds of things in between. The point, though, is that the person needs extra assistance with mobility. Why do mobility impaired residents suffer unique harms when there are failures in oversight? Mobility impaired residents often need more care from more staff members than other residents. They may be unable to get out of bed and walk to use the bathroom without assistance, may be unable to get out of bed to get a drink of water or to find help when needed. Things that a lot of people really take for granted being able to do on their own. Many nursing facility residents with mobility impairments require assistance to do all of those things. They have a higher level of care need. So what does this mean practically for nursing facility residents with mobility impairment? I'm going to give an example from a plaintiff in our complaint. This resident was admitted to a nursing facility following a hospitalization. They had several conditions that limit their mobility. They relied on 2 staff members and a mechanical lift to transfer in and out of bed and a wheelchair to ambulate. This resident was also incontinent, and they had a plan of care detailing what level of assistance they needed for all of these different things. Now, this resident's plan of care required that they be transferred out of bed every day, but the facility often did not follow this plan of care, instead leaving him isolated in bed for the entire day. When this resident was transferred, oftentimes the facility used only 1 staff member and a mechanical lift instead of the 2 staff members and mechanical lift required by his plan of care. The results were not always disastrous, but they were on one occasion when the lack of appropriate care in transferring led to a fall and the resident's hospitalization after he struck his head on the lift. This resident reported waiting more than 15 hours for incontinence care and often going an entire nursing shift without any incontinence care. So here we have a resident who is not always able to get out of bed. Sometimes he's isolated all day. And when he does, he's putting himself at physical risk if the transfer is not appropriate. And this resident knows they can go hours and hours without needing incontinence care. So what's more, when this resident was transferred out of bed and was able to ambulate through the facility in his wheelchair, if he needed incontinence care, staff told him that he would have to return to bed, receive the care, and then not transfer out of bed again.
Liam, you froze on our side.
Until the next day. Am I back?
Oh, yes. Yeah.
Yes.
Am I back?
Yeah.
Am I back?
You're back,
Oh,
but
no.
your screen is frozen. You might want to take the video off because I think that could help with the bandwidth. Oh, there you go. Hi. Yeah.
All right. I won't bother switching computers then. How long was I out?
You were saying about the resident essentially being put back into the bed for the day.
Oh, sure.
Yeah.
Perfect. Thank you. Yeah, so that's an impossible choice, right? That nobody should be put to. The facility also did not provide the resident with showers consistent with their care plan, and the resident complained that they would be left with their call bell unanswered for extended periods of time. So this sounds a lot just talking about what the facility didn't do right. But our case, the point is about oversight. In this case, this resident had filed a complaint with the state survey agency about the failure to follow his plan of care and about his treatment. As of the time of the filing of the complaint, more than a year had passed with no investigation and no annual survey at the facility. So had the survey agency followed its protocols and guidelines for complaint investigations, it could have investigated the complaint, reviewed the plan of care, found deficiencies, potentially. We're not trying to read into what they would have found. The point is that these mechanisms are in place through state survey agencies when the facility is not doing what it's supposed to do. But if the survey agency does not get out to investigate, then mobility impaired residents continue to suffer their unique harms within the facility. I'll just note, because it's not a part of that plaintiff's story, it's very common to see mobility impaired residents experiencing pressure ulcers, UTIs, and falls. Yeah, really, it's only mobility impaired residents that are gonna suffer pressure ulcers generally. So that's very common and a big unique risk for mobility impaired residents. And with that, I will hand it back to Regan.
Thanks, Liam. So Liam's walked us through some of the unique harms that people experience that we included in our complaint. In April of this year, the court issued an order addressing two things. One was the state's motion to dismiss. They wanted to dismiss our case and kick us out of court. And the other one was our motion for class certification. When deciding a motion to dismiss, the court has to accept our allegations as true, just for the purposes of whether or not we have stated a viable complaint. We've made a real claim under the law. But also has to find that the plaintiffs had to have a viable legal theory. So it's the facts and the theory that the court looks to. So they don't find facts, but they look to the theory and say, would those facts support this theory? So we haven't actually gone to court to prove our facts, but we're confident in our facts because of our multi-year investigation. So we were really encouraged when the court denied the state's motion to dismiss, because that meant that the court has accepted our legal theory of the case. So the state argued that the plaintiffs didn't suffer a concrete injury because of a lack of surveys, and that its actions are not the cause of the care issues they experienced. They're saying that's the nursing facilities, that's not us. The court rejected the state's argument that the denial of oversight and enforcement function was not a concrete injury. And the court said, and I quote, "The injury created by Maryland Department of Health's procedural failures is connected to a variety of concrete, physical, social, and emotional harms and risks identified for each named plaintiff." So this meant the court had accepted a major piece of our theory. The state also challenged whether or not we had made a claim, a valid claim under the law. So as I mentioned earlier, our legal theory is based on a methods of administration claim, and that's under two federal statutes, the Americans with Disabilities Act and the Rehabilitation Act. So we read those together. They are read together, and we brought to those statutes the obligation of the state to follow other federal statutes, the Nursing Home Reform Act and state statutes protecting resident rights. So that sounds a little complicated. What we're really trying to say is the way that the state tries to comply with the federal law is discriminatory. They don't comply with it correctly. And the impact is and that has a disparate impact on residents with mobility impairments in nursing facilities. I hope that's clearer. So a disparate impact case, it means that the impact is where the practice doesn't target the people with disabilities for discrimination, but they experience a greater harmful impact. The court found that, quote, "The facts alleged in the complaint draw a causal chain from Maryland Department of Health's failure to fulfill oversight and enforcement obligations imposed by the Nursing Home Reform Act to specific harms and risks suffered by the plaintiffs that are unique to nursing facility residents with mobility impairments." The court also granted our class certification. The state's failures across nursing facilities and disparately impact the entire class with a common set of harms and heightened risks. We sought relief that would benefit the whole class. That the state timely conduct nursing facilities, for example, every 16 months for standard surveys and within 2 to 16 days for complaints involving harm. The court's order granting our class, which I clarified at the beginning, the court's order reflects a clarification in the law that states who do not oversee and enforce quality and rights protections afforded to residents under the Nursing Home Reform Act and state law violate the Americans with Disabilities Act when that failure has a disparate impact on a discrete class of residents, such as those with limited mobility. This theory can be used in other contexts. Because they found the state is liable where there's a link between a lack of oversight and enforcement and a traceable harm to downstream residents, we could look at this in other states. So are states failing to conduct nursing facilities or investigate complaints in other states? It could also be looked at it in the terms of the fire and safety inspections. So states have a similar obligation under fire and safety standards, Medicaid fire and safety standards, to address risks, particularly around fire. And the failure to ensure that those plans are viable leaves residents vulnerable to fire, flood, or other natural disaster. We saw in the LA fires, for example, last January, and during the back-to-back hurricane season in Florida last fall, that some people were, there was suggestion anyway, that there were poor planning in the nursing facilities because people had experienced poor outcomes and were not evacuated in a timely and safe way. So we believe this is an important case for holding states accountable to residents for their oversight and enforcement of resident rights and quality standards. And because of this order, we are now at the negotiation table with the state. And they're working proactively and in good faith with us to settle the case and make sure that surveys and inspections are done timely and the information is shared publicly. And that is all we have for today, but we are available for questions.
Thank you so much. I'm going to hop back on video here. I'm going to share my screen. I just have a couple closing slides and then we will move on to the Q&A. So let me just share here. Okay, there we go. So thank you so much for our speakers today for walking us through this truly groundbreaking case. We were really thrilled to bring you this discussion today. And it's so important to, stand up to and say that these state agencies must do their job to protect those in long-term care. So thank you again for your work on this case and for taking the time to discuss it with our audience today. LTCCC's next webinar will be on October 21st at 1 p.m. Eastern, and we'll be hearing from the Center for Medicare Advocacy about navigating Medicare Advantage. The registration link for that webinar is at the bottom of your screen, and we will also be sending out more information for this webinar soon. So just make sure that you are signed up to receive alerts from LTCCC. You can head to Nursing Home 411 for materials from today's webinar. As I said before, this will be, it's being recorded and I will post the recording by the end of this week, along with all of the documents that our speakers discussed today. Please follow LTCCC on social media for updates, upcoming webinars and other events and more. And visit our Learning Center for fact sheets on key nursing home standards, assisted living guides, family empowerment resources, and we also have our Resident Abuse, Neglect, and Crime Reporting Center. So again, just please make sure that you are signed up for LTCCC alerts so that you can stay in the know about all things going on. If you have any questions or comments, again, put any questions for our speakers in the Q&A so we can get to them now. And I'll hand it off to you, Richard.
Thanks so much. And thank you again, Regan and Toby and Liam for your work and for presenting today. So I will get right to the questions. We have an anonymous attendee who said, I would love to learn more about how Maryland has increased oversight of their state agency, particularly by their state legislature. I'm not sure if, but I'll leave that to you.
Did I take that, Regan? Yeah, so I am not an expert in this, but I can tell you generally that in the most recent legislative session, the Maryland legislature passed a new law to require the OHCQ, the survey agency in the state, to report on surveys that were conducted, the results of those surveys, I believe on a quarterly basis, and I believe it's also divided up by geographic region, I think county. So the idea is that the legislature is seeking to have like up-to-date timely information about where the agency is at in terms of being able to comply with the requirements to conduct the surveys on an annual basis.
Thank you. Thanks, Liam. The next question is from Gary Bennett. Is any legal services agency in New York considering a lawsuit against New York similar to the Maryland lawsuit? Excuse me. My understanding is that New York DOH is not following state law. I guess why don't I just quickly answer this? I am not aware of any New York state laws that impose more criteria on the state agency, which is the State Department of Health. And I don't think that there's, we could speak at this point to anyone who's considering a similar lawsuit, but certainly our whole idea in hosting this is to give make others aware of what's going on and hopefully, and hopefully support efforts to hold other state agencies accountable. The next question is from Tanya Kessler. And she says the complaint is fact-rich with compelling stories about the named plaintiffs. How did you find the nursing home residents you met with during your investigation?
Thank you. That's a good question. We spent years, I said, working up this case. We did a lot of outreach. We went out to nursing facilities. We work with local advocates. There are some peer groups that go out to nursing facilities. We talked to the long-term care ombudsman. And they've shared our information with people on the ground, and then those people could contact us, the residents. So it was a real team effort. We did a lot of outreach in the state, and it took a long time because we were learning more and more every week about what was going on, and the data was shifting, and just understanding how the system was working and what the levers were took some time. But the residents themselves, we met with a lot of people, and that's really what guided the direction of the complaint.
Wow, thank you. Thanks very much. Carl Varner asked, any merit to the use by residents advocates of the reasonable accommodation / modification provisions of the ADA or FHA to improve quality of their care and of life in facilities? As an ombudsman, I use the residents' rights approach that I am responsible for in my negotiation to improve outcomes for residents. But I do not have enforcement power, and my negotiation may only go so far. For reasons you have touched on, state surveyors may not always be able to respond to complaints in a timely way. So how about advocates using the added force of these ADA provisions to maximize the ability to succeed in pursuing justified care plan related goals?
So our case was really about the piece here you're talking about where they're not responding in a timely way. That's the missing link here, right? So that's what we were trying to bolster. Obviously, reasonable accommodation modification provisions are applicable in nursing facilities, but that wasn't a piece of this case. And ultimately, what we'd like to see is the state enforcing the law rather than advocates having to do a workaround. So this sounds like a good stopgap measure, but in the end, we would like to see the states actually doing surveys and complaint investigations in a timely way and enforcing the law.
Could I just say something about that in response to what Regan just said? I am not a litigator, but I'm a nursing home advocate. And one of the things I loved about the judge's decision was a recognition that the survey and enforcement system really matters and can make a difference. This is what he said. The threat of he said, just the enforcement remedies available to Maryland Department of Health are far-reaching. Then he said, the threat of having federal funding terminated or being shut down supports a reasonable prediction that nursing facilities would respond to consistent annual surveys, timely investigations of complaints, and any corrective plans by MDH in ways that would put an end to plaintiffs' personal risks and harms. He's saying it matters. If the enforcement agency does its job, it would make a difference in residents' lives. And that's a strong statement. And I thought that was very powerful and important because we spent a lot of time trying to convince CMS that their work matters to residents' lives, right, Richard? I mean, we're fighting all the time. What you do matters. We need you. The residents need you. And this was a strong endorsement of the importance of the regulatory system in protecting residents. I thought it was just a great decision. Really tremendous job.
Thanks.
Yeah, and this is, I guess, is our mantra coming out of this case is file those complaints, make the system work. And that's really, we really have to insist that it works. That's what it's there for. We put a lot of money into it. The state gets paid. So make them do their job.
Thank you. Thanks. Andrea Cabsinel, I hope I'm pronouncing your name correctly, asked, can you say more about the state working to settle this issue?
No, not a lot more. We're actually in settlement discussions. All I can say is pretty much what we said. They've come to the table in good faith, and we're having productive meetings.
Thank you. Thanks. Catherine Wicker asked, thank you for all your great work. Can you please describe in more detail the investigative process you undertook before filing the complaint? Was there any type of statistical analyses performed? I would love to hear more. Thank you.
We looked at a lot of data. Besides the outreach for the plaintiffs that I talked about ahead of time earlier, we looked at a lot of data across CMS websites. We looked at quality indicators. We looked to see what kind of harms people were experiencing as a result. We looked at the delays between surveys, any data that the state put out. We're not statisticians, but Liam's gotten pretty good at it. So we did a lot of a detailed analysis trying to identify, for example, the percentage of people with mobility impairments across nursing homes, because we wanted to make sure we were addressing the larger problem as well as a narrower problem. So I hope that answers your question, but the answer is yes, there was statistical analysis performed. Liam, do you want to add to that?
Yeah, if I can just add, we also, with statistician partners, undertook an analysis to determine whether there was racial disparities in terms of quality within nursing facilities. And as Regan talked about during the presentation, we found that there is, that predominantly Black nursing facilities in Maryland tend to provide lower quality care. So we worked with statisticians to reach that conclusion.
Of course, national data supports that as well.
If I could ask a quick follow-up, when you looked at nursing homes that are serving populations of color or Black, I think as you put it, did you look at the actual resident population, or did you look at the community population?
We looked at the resident, and the reason why we focused on Black residents instead of the broader persons of color is that's how the data was broken out at the nursing facility level by the state. So that was specific to Black residents. And they had, and Maryland is one of the few states that puts that data in the public domain.
Thank you. Thanks. An anonymous attendee asked, could you talk more about the process of investigating and developing this case and working with class plaintiffs? What efforts were required and how your team worked, to the extent you're willing to share? Thank you.
I'm not sure how that's different. Yeah, hopefully I've answered it.
I think I understand it a bit.
Okay.
This may not be what you're getting at, but given that our class, our plaintiffs, our nursing facility residents with mobility impairment, oftentimes we had to take steps to ensure adequate communication with them, like visiting in person, having multiple visits, accommodating needs for different types of communication through technology and that kind of thing. I think that's the way I understood that, was that this is a difficult population potentially to reach without that on the ground, hands-on meeting with people. And so our local partners especially were instrumental there in connecting with folks.
Do you think,
just to build on that, it's difficult because of privacy concerns. So, there's roommates and things. So that's why we would go on site or set up a secure video link so that we could have conversations that were private.
I have a question. Did you find offering anonymity to the plaintiffs, that they would not have to be named in the complaint with their actual names, made people more willing to be plaintiffs in the lawsuit? Because I know when we filed the Valdivia case, when California said it wouldn't implement the reform law, advocates spent the summer trying to identify plaintiffs. We had 2 people, but they were named with their actual names. I wonder if saying you can be anonymous would give them, protect their privacy and make people more willing to participate, because it's critical.
Well, we did offer that to the named plaintiffs because as you read the complaint, there's a lot of very private details in there.
Right.
And it's not the kind of thing you necessarily want associated and have in the newspaper, for example. So we offered that to them and ended up with a sealed complaint and changed names.
Thank you. The next question is from Roxanne Montgomery. What does a settlement look like? What assurance is there that the settlement is implemented, enforced? This is, I would say perspective, of course, but in terms of what you're thinking.
Yeah, so I can't say a lot about what's going on in any negotiations. So, we will stay involved after if we reach a settlement and monitor and ensure that the terms of the settlement are followed and enforced if necessary. We always do in our cases.
Anonymous attendee asked, what is the oversight regarding medication administration, for example, missed and incorrect dosages? I see this occurring on a regular basis with disastrous, sometimes fatal results. Virginia has been exceptionally slow to investigate complaints of this nature. I don't know if you want to take this or not. I'm not sure if it's really in the purview of.
Yeah, again, this is the kind of thing that there should be complaints on, and if they're not responding to those complaints, depending on the medication, it could be an immediate jeopardy situation. So that's something, to be concerned about, but I don't know what to say beyond that in this context. Liam, do you?
Oh, the only thing I would add is just that Virginia is now one of the states that's woefully behind on their surveys. So it doesn't surprise me to hear that the complaints about medication administration are not being investigated promptly. I would just say that we are always concerned about delays in investigation will lead to things like witnesses not being available, people moving on. But medication administration is one where there's records. There's usually, there can be records. I've seen plenty of instances where there are records. So I would especially encourage people to not get discouraged about things not being timely investigated, still file the complaints.
I guess the only other thing I'd say about medications in particular, if we have missed dosages or lower amounts, what kind of medications are we talking about, and do they have a street value? You might want to contact the Attorney General's office on that.
Yeah, thank you. Thanks, Megan. Another anonymous attendee asked a question that I think it's a little bit tertiary to your discussion today, but this person says our state isn't very far behind in surveys and tends to be timely, but the problem we have is that survey agency only substantiates 3% of complaints, including those verified by the Ombudsman program. Is this a common problem, and is there anything we can do to help solve it? So if I may start, it is a common problem. We have done at LTCCC a number of studies of federal data, and they're on our website. The last one is called Broken Promises, and we're undertaking a new study right now looking at the federal data, showing for each state the extent to which their citations, the extent to which they are citing facilities and recognizing harm and immediate jeopardy. But I just wanted to mention that. But I don't know if there's anything you, Regan, or Liam, or Haley, or Toby, excuse me, want to add.
Well, the only thing I would add is that the states are given a lot of discretion here. There's Supreme Court precedent that controlling cases that make bringing a case on this extremely difficult. It is a problem. It's something we've looked at, we've seen, we're concerned about, but we don't have a theory to attack it yet. So I don't know, Toby, if you have anything to add to that.
Well, I would just say that I think one of the concerns we've had over the years is that surveyors don't have investigative skills. And if they don't see something with their own eyes, they are likely not to substantiate the complaint. They have to see it with themselves. And, criminal investigators, for example, don't see murders with their own eyes. I mean, usually it doesn't happen in front of the investigator, but they know how to do an investigation and to substantiate something that they haven't seen personally. And I had an experience some years ago with a surveyor who had been an investigator in the Attorney General's office, and she was able to substantiate that this particular nurse was, giving pills to residents to basically to kill them, maybe like an angel of mercy. He thought he was doing a good job, helping people who were suffering. But this surveyor knew how to investigate and find out what had happened. And most surveyors just don't have those skills. And that's something I think we should encourage for training of surveyors, how to do better investigations.
Liam, did you want to?
No, thank you though.
Sure. So just to add, we have on our website, Haley had mentioned that we have a crime and abuse reporting page. We have the links there to the regional offices of CMS. They're now called CMS locations, and they are responsible for overseeing the performance of the state agencies. And we have the email addresses there, so you can file a complaint with them if you're unhappy with how a complaint was handled by your state. In addition, we strongly encourage people contacting their state and congressional representatives when they see problems that are not going addressed, because that helps raise the issue more publicly and potentially has a political, I wouldn't say a solution, but it could have some political effect on those agencies. It's just important, just quickly, to keep in mind that the nursing home provider industry is obviously a multi-billion-dollar industry, and they have, I believe, in every single state, a lobby associations as well as the national lobby associations. So they are there in our state capitals and of course in Washington, D.C., constantly pressuring for less oversight and pressuring the states and CMS to do less. So it's really important. Your voice is important, and all our voices are potentially important to speak out against that, because residents don't have million-dollar lobbyists, but the nursing homes do. I'm going to quickly move on because I know we have a lot of questions. So Roxanne Montgomery asked, SB 0376, the quarterly reporting is not detailed, just counts of inspections per county per quarter. This is from Maryland. It's not really a question.
Well, I think that's true, but I'm putting in the chat the website, the CMS website. I don't know if I can do this, but I will try. Why isn't it letting me send it? Maybe I can put it in the question. Yeah, there you go. This website, can you see it?
I don't see it.
Once I typed the answer and I sent it. No,
Is it the Q-Core website?
Yeah.
Okay,
That website has a lot
I'll
of
try to put that
data.
in the chat.
Thank you. That website has a lot of the data that we looked at, and it is updated more frequently. I think a lot of the data that's going on the Maryland site is duplicative of other data, but it will make sure the legislators informed, which is good.
Carl Varner asked, who were your statistician partners and how were these staff recruited?
We have a relationship with the university, and they give us some assistance there.
That's great. Kate Tyberg asked, do the nursing home facilities have the funds to purchase technology to better communicate between residents and staff? That's not really, to be honest, I don't think that's relevant to this, to what we're talking about today. Sorry, Kay. John Rhoda asked, mention was made about Maryland, making racial data available. Do other states gather the same data but not release it or not gather it?
So to my knowledge, there's no federal requirement to gather race-based data of nursing home residents. So it would be a state-by-state basis, and we haven't done a 50-state survey on that.
Thank you. Thanks. Last question. Again, I'm sorry.
And it might be an MDS data if anybody's looking for it.
I think it is. It's kind. I mean, actually, John,
Is it?
I've looked at that. Well, there's There's some, I think the MDS data touches upon it, but I don't remember if it's as specific, which is why I had the questions I had earlier on about how you were identifying the racial makeup of the nursing home residents that you were looking at.
We haven't seen it in other states, and I don't know if we've been able to capture that data from other states. So, but we can look.
Thank you.
But we can't bring the claim. That's the frustration there, is we can't bring the claim because of Title VI's limitations. These race-based claims for disparate impact are not privately enforceable.
Right. Oh, interesting. Thank you. Our last question is from Wendy York. Do you see an opportunity to have the Connor ruling extend to state agencies overseeing assisted living or adult care facilities?
I think that the theory would work there, but it wouldn't be the Nursing Home Reform Act. So you'd have to look at your state protections for assisted living facility residents and see if that's the oversight is happening in a way that discriminates against a subclass within that service.
Great. Thank you. Thanks, everyone. There's another question, but that was actually answered before. So I'm going to wrap it up now. Thank you again, Regan, Liam, and Toby. Really appreciate the work that you're doing and appreciate you sharing it with us. As everyone could see today, there's no PowerPoint presentation, but there are materials, and we will be posting it along with the program recording on our YouTube channel and website by the end of the week. So thank you, everyone. Have a great afternoon.
Thanks for having us.
Thanks. Bye-bye now.
Bye.